My Lords, I'm sympathetic to the government's aspirations to tackle fraud, to reclaim money effectively ripped off from the public purse, whether it's those grants for fake community schemes mentioned by the noble Baroness Anderson of Stoke-on-Trent at the beginning, to the more mundane benefits cheats. There is nothing more galling for the public, I think, than people who exploit the system, for those who work their guts out and struggle to make ends meet, who then see a minority who are claiming benefits that they don't have a right to, and yet seem to have a better standard of living than the people who are working so hard. It can be and is infuriating. But yet, I have some serious reservations about how the government's approaching this, and parts of the bill at least feel like a sledgehammer to crack a nut. There's a nagging feeling that the government is going after low-hanging fruit, and it's become a distraction from the real culprits and deeper problems, and indeed some dodgy schemes created by the DWP or allowed by the DWP. In the recent furore about the apparent ease with which some could use the Motability scheme to access fancy cars, for example, to get state-paid insurance, excise duties, servicing and breakdown cover, the upset was, of course, not about a scheme that allows those with disability to access transport to aid their independence. The British public are fair like that. They want that. Rather, it seemed to me that the upset was because there were systems, legitimate systems, set up by a private company that ran Motability that were there to be played. It wasn't fraud, but there was lax assessments, a management who never queried why its customer base swelled by 14.7% in the last year, and executives who were awarded eye-watering pay bonuses, who boasted that their scheme was the largest car buyer in the UK and doing a public service by promoting electrical vehicles to help deliver the transition to greener transport. Maybe that's why the government turned a blind eye to what was obviously and what needs to be tightened up. So I think that there's more going on when it comes to the issue of welfare being exploited than sometimes this bill allows. But back to the bill. When I first heard about the Public Authorities Fraud, Error and Recovery Bill, no disrespect, but it did sound a bit dull, technical, workmanlike. And I thought, I won't bother with that, I'm not going to get involved. Problem was, I then read it. There's a good reason why it's been labelled a Big Brother deal, a snooper's charter, allowing mass surveillance of those who get means-tested benefit, as we heard by the noble Lord Garnier, some of the concerns. And I agree that one of the most contentious parts of the bill, as we've heard from others, is the eligibility verification measures that, frankly, I find quite worrying. The government seems, however, to be quite matter-of-fact about this new requirement, ensuring that banks and financial institutions trawl through their data sets to highlight where someone may not be meeting the specific eligibility criteria of certain benefits. Apparently, the attitude is, if it helps the DWP identify incorrect payments and verify or otherwise claim its entitlement to public money, it's okay. That's the justification. But I feel queasy. I also think it's peculiar that we think it's okay for the DWP to outsource the dirty work to private third parties that are, first of all, unaccountable to the public, but also they're being forced to do a job the DWP should be doing itself. Because coercion is involved. The banks don't have a choice. They're not being asked if they want to do this. They'll be served with a special eligibility verification notice setting out the specific information the DWP requires, and there will be penalty notices for non-compliance. This itself seems an example of huge state overreach. This will also mean that banks, building societies, etc., will have to trawl through all account holders' databases to identify which match search criteria supplied by the DWP, criteria, by the way, that's not available to us as legislators to scrutinise, or in fact the banks. I therefore understand why Big Brother Watch and Privacy International and other civil liberties organisations have invaluably raised the alarm about what has been labelled bank spying powers. And ministers have responded by suggesting this is an alarmist hyperbole, a kind of nothing to see here. Now, I do appreciate that this Labour government has more tightly drafted the bill than the previous Conservative government's version. And yes, it is good that the bill does limit the powers of eligibility verification notices to only request information about accounts in receipt of 3 named benefits. That's good. But when reading the notes for this, the bill notes that this is initially the benefits that will be looked at on the one hand, and also the bill contains the authority for the Secretary of State to expand the range of benefits covered at any time in the future, when Parliament reduced to a nodding dog status rather than us being able to debate it. I'm sure all these details will be subject to debate and amendments at committee, but for now, just to take a step back and note that whatever smoke and mirrors the government deploy, the facts are these, that some people on benefits, and by the way, often people with associated accounts that maybe their carers or guardians, i.e. account holders not even on benefits, will be subject to having their private financial data preemptively monitored, intruded on by banks and other financial institutions in case they're involved in fraudulent activity, all without their knowledge, and all because of coercive orders given out by the state. In the other place, there was an interesting amendment tabled by Labour MP Neil Duncan-Jordan. He sought to limit the exercise of an EVN to cases where the welfare recipient was suspected of wrongdoing and expressed concerns about, quote, the slippery slope of compelling banks to act as an arm of the state. The government's rebuttal of that amendment was revealing. Mr Duncan-Jordan was told that this would, quote, undermine the measure entirely, as powers in the bill are not intended to deal with suspected fraud, but to, quote, help check that claimants are meeting the criteria for their benefits and to detect incorrect payment at an earlier stage before any suspicion of wrongdoing has arisen. This is suspicionless surveillance, and I don't think that that's a good answer to the problems that we're trying to tackle. And I'd argue that the government should note, on principle, that we shouldn't intrude on citizens' bank accounts without very good reason. It risks an important commitment to the innocent before proven guilty point by treating all those on certain benefits as would-be criminals by default. And some might say, civil liberties be damned, it's all worth it to crack down on cheats and reclaim all that misappropriated money. However, I then think that we must remember that even from the government's own analysis, if it works, this particular measure, this unprecedented bank intrusion, is expected only to recover less than 3% of the estimated annual loss to fraud and error. Beyond bank spying, there are parts of the bill that also make me gulp, and I won't go into most of them, but I did want to ask the Minister whether she thinks that boasting about the use of non-criminal penalties is appropriate. It's explained benignly as a way of reducing a burden on the courts that can be costly and time-consuming, that civil penalties will show that there are meaningful consequences for breaking the law, we heard that at the beginning, even when criminal prosecution is not achievable, i.e. there's not sufficient evidence to get a conviction. Should we be welcoming this non-optional use of civil penalties because they have a lower burden of proof, i.e. on the balance of probabilities, rather than beyond reasonable doubt, i.e. it's easier to convict and find someone guilty because due process is sidelined? Finally, we've talked about, other people have mentioned the fact that there is a danger of eliding fraud and error, even though the government goes to great lengths to distinguish between them. And when it comes to detection and recovery, they are indistinguishably punitive for both. But also, too often, as we've heard from others, overpayment errors are the fault of the DUP. But little attention is paid to this failure in this bill. A Freedom of Information request has revealed that between 23 and 24, nearly 700,000 of the new universal credit overpayment debts entered onto the DWP's debt manager system were caused by government agency mistake. Yet all this bill's powers focus on making claimants pay the price. In an insightful article by Sian Berry MP, somebody I don't usually agree with, she quotes the CEO of the Public Law Project, who points out, quote, that no one is expecting the DWP not to make mistakes. However, it is incumbent on the department to take responsibility for those mistakes rather than pushing that burden onto people it should in fact be supporting. And while this bill is keen to punish even those who make unintended errors, perhaps not supplying the correct paperwork or missing deadlines, the government itself could be accused of equal negligence. In reply to lots of the issues raised today, the government will tell us that much of the detail on safeguards, procedures, appeals and fines will be contained in 3 key codes of practice. Yet not even drafts of those codes of practice were published before the bill finished in the other place, and we won't get them, if we do, until committee stage. This breaches the spirit of the official guide to making legislation that sets out the procedures by which a code of practice should be made available in order to properly consider the appropriateness of statutory provisions should be made available. We haven't got them. So I would say look to ourselves before we start over-punishing the most vulnerable. And now if I can hand you over to something far more edifying. I'm delighted that I'm going to be followed by the noble Baroness Spielmann. I've long admired her, often agreed with her from afar. She might not actually, her credibility, I hope, won't suffer from my endorsement, by the way. Do feel free to distance yourself. But anyway, I look forward to hearing your maiden speech and to many speeches that you will make in the future.